Good to go. Thumbs up. I now welcome representatives from the Department of Education and the Tertiary Education Quality and Standards Agency. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to parliamentary committees has been provided to you. I remind members and senators that the Senate, the rules of which this joint committee is bound by, has resolved that an officer of the Department of Commonwealth or a state shall not be asked to give opinions on matters of policy. This resolution does not preclude questions asking for explanations of factual policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground on which the objection is made. The committee will determine whether it will insist on an answer, having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that an answer be given in camera. Officers are also reminded that any claim that it would be contrary to the public interest to answer a question must be accompanied by a statement setting out the basis for the claim. Right, for the Hansard record, would you please state your full names and the capacity in which you appear before the committee, and we'll start on my left.
Hello, my name is Adrian Neuenhaus. I'm the Acting Chief Commissioner of TEQSA.
Welcome.
Hello, Mary Russell. I'm the CEO of TEQSA.
Ben Rimmer, Deputy Secretary, Higher Education Research and International, Department of Education.
Kate Chipperfield, Assistant Secretary, Higher Education Division, Department of Education.
Welcome to you all. I'll now invite you to make an opening statement, then we'll open up for discussion.
TEQSA does not have an opening statement. Thank you.
No worries.
Chair, we don't have an opening statement.
Just ready to rock, ready to have a chat.
Ready to rock and roll.
All right. Why don't we just dive into it then? Well, then I'll start with TEQSA, because obviously the work you've been doing around university complaints processes, especially for sexual assault on campus. What are the main lessons that you've learned as part of that process and recommendations for improvements for universities in order to improve the confidence and the utilisation of those sorts of processes and the effectiveness of them?
Yeah, look, that's a very helpful question. So we have had learnings within TEQSA that have informed our approach to concerns about anti-Semitism and the response to the protests. So it has certainly helped us to understand that where there are systemic issues, it's important that as the regulator we turn our attention not only to what the incident responses may be and the learnings that universities need to take forward about their response to critical incidents like protests and encampments, but that we also turn our minds to what are the broader system improvements and actions that are needed to strengthen the university environment going forward to prevent further occurrence, make sure that improvements can be made that do the best possible job of ensuring a safe and effective environment for students. So that has, for example, informed the way that we have looked at concerns students have raised with us about complaints processes and processes for seeking academic adjustments. And we...
Some of those sorts of concerns?
So, for example, students have felt that when they have been seeking academic adjustments, we've heard a number of reports that they have been in a system that requires them to provide written evidence, and yet students may not be placed to be able to provide written evidence that they have family or friends in the Middle East who have been subject to kidnapping, other sources of trauma. It may just not be available, but the complaints processes or the processes for seeking academic adjustment haven't been trauma-informed enough to recognise that, to minimise the retelling of students' stories, to be flexible in understanding the type of experience and the type of adjustment that they need. So certainly some of our work now is about what we will be requiring of students to adjust those processes.
Which university was that?
There are multiple universities, and some of those concerns have been raised with us by student groups who have chosen not to say which individual university. So we're approaching that across the sector as something all universities must attend to.
100%. I'm more just interested in the fact that you mentioned that there was a specific incident around someone who had potential family member involved. They asked for special consideration in academic adjustments, and they were asked to provide written evidence of which that was unavailable. And was that special consideration granted at the time?
We don't know. That was brought to us by the Australasian Union of Jewish Students, and so we don't have the direct particulars of that. But I'm certainly raising that as an example in all my discussions with universities.
So that, or just didn't tell you which university that was involved in?
No.
Right, just as an example.
Yes.
Okay. And in your view as a regulator, would that be should universities have that sort of threshold in that sort of instance?
So our view is that not enough has yet been done to transfer the learning from gender-based violence to both complaints processes and processes for seeking academic adjustment. And that's part of what we're working on now with universities.
And so let's unpack it then. What are the sort of steps that universities need to take to ensure that there is both access and appropriate use of those complaints processes in line with the learnings from the sexual assault processes?
Okay, so certainly our view is that both of those types of services need to be trauma-informed, and that's something that has happened in gender-based violence services on the whole, but has not yet transferred to these other processes. There should ideally be a single front door so that the student can approach the university about a concern or about a need that they have and not have to then begin from scratch with a number of different services within the university. It's important that where that student has had appropriate support, be that counselling support, be that medical support, other support, and it's been determined that they need particular adjustments, that they don't have to provide detailed personal medical or other information again and again and again to staff who don't have need for that, that the decision about the type of support that is needed can then be implemented by academic staff at faculty level. So it's important that those are timely responses as well, and they have not always been.
Thank you for that answer. Just so it's clear in my tired brain, so students are currently going through university processes where they're seeking academic adjustments. They're being sent around from different department to department, and each time they're being asked to provide a new round of fresh evidence or a new form or a new this, and that's not being shared. Is that your observation?
That's the case in some instances, not everywhere.
Right.
But that might also mean that a student who needs to seek academic adjustment for 4 different subjects that they're taking might have to make those submissions to 4 faculties and have 4 different committees consider them. So we think those sorts of things need to be better managed to reduce the adverse impact on students.
So that should be taken out of a faculty management and should be taken by a sort of central agency inside the university?
That's one way of approaching it. Another way is to accept that if there is an appropriate sort of appropriately skilled and auspiced kind of person who sort of says this student will need extensions, they will need an opportunity to take a deferred exam, they may need to take their exam in a different set of circumstances, that should be taken as the advice the faculty acts on rather than having to go over the particulars of the incidents or impact that has had on the student.
So ideally, what you're saying is a student goes to an easily accessible university complaints process. They make their complaint, they ask for their adjustment. They make a determination based on the specifics of that student. If they make that determination, it is then their responsibility to then contact the different faculties in which the student has requested academic adjustment for, so as to reduce the burden and the trauma and the and that's not happening at the moment? Not uniformly, and it's an area that we will be targeting for improvement. And if I may say also that may not be one-off. It may be that where the impact of that is going to be persistent for the student, that they once again shouldn't have to go through that process every semester. Obviously, depending on whatever the specifics of the student are. Yeah, that makes sense. So which universities are doing this as a sort of best practice at the moment?
Monash has been a leader in the way that they deal with student concerns and trauma-informed approaches. Some universities are partway there, so they might have a really good front door, but it doesn't articulate then with their complaints processes or their faculty kind of consideration of requests. So some of that is the work that we're requiring is going to be about making sure that pathway is consistent and clear and effective.
And can you unpack Monash's approach and why you singled them out? In a good way, not in a...
So I think that Monash has done a lot of really good work to think about what trauma-informed engagement with students looks like in their context, and they have also done good work to understand what different sets of circumstances how they might need to be understood and dealt with. So I guess that one of the things that is clear to us is that a complaint service will need to have very good systems and processes for all students, as will an academic adjustment process. Staff will need to have training in working in trauma-informed and empathic ways, but they may still need to understand what are the specific experiences, traumas and issues for students who've experienced anti-Semitism, which may be different from those who've experienced gender-based violence, which may be different from those for students who have disability. So it's about also recognising that the generic needs to be complemented by specific understanding, and that should inform responses.
Thank you very much. Let's go to confidence in complaints processes, because obviously it's not just the journey of having to explain your situation over and over again, which you've spoken about, Dr. Russell, which I really appreciate, but also the faith in which the universities are actually taking seriously having a process, and then being able to transparently say, well, this is what's happened. Some of them we've decided this, some of them we've decided that, and even in the hearings this morning, we had quite a range of universities willing to disclose their own outcomes of their own processes, all the way from we're going to start a process sometime next year, all the way through to here's how many people had this X many outcomes, and they read it out here. I mean, what's your observations around the range, first of all, of complaints processes and transparency around it? And then what do you think is the best practice in order that universities to be able to give that confidence to students to know that their complaints will be taken seriously?
So I would answer that it is in some ways difficult to say, because there's not a lot of data to base that on. So we received very few complaints that were specific to we're not satisfied with how a university is responding to complaints or concerns that have been raised. I think the introduction of the National Student Ombudsman will give another really important student-based pathway for those concerns to be raised into the future. We, as a way of trying to test this, early in the protests and encampments, we asked universities over a period of 6 weeks to provide us with updates about the complaints that they were receiving. And the reason for doing that is because we weren't receiving many directly. We wanted to have some evidence that they were receiving and acting on complaints. And the results were that at the campuses where there was significant activity, there seemed to be significant numbers of complaints and concerns being raised. So that provides some level of confidence that at least the processes were available and being used. We would balance that against some of the accounts that we've had, for example, from AUS, that students felt that they were uncomfortable with complaints mechanisms because they weren't necessarily clear or confident about whether they could make a complaint confidentially or anonymously. And there was some interesting feedback about ways of complaining needs to be fit for purpose. So, for example, Deakin had an app which meant that students could just photograph what they believed to be, anti-Semitic symbols or slogans. They didn't have to go and make a formal complaint. That was registered and dealt with. So I think just thinking that complaints mechanisms need to be a traditional complaints process is probably more narrow than what students are looking for.
But you have no issues with universities publicly reporting on, obviously not the names of individuals, but the outcomes of their complaints processes?
We don't. And I think, Chancellor French highlighted that was, one of the recommendations of the initial, French report, that is good practice. We would expect that is regularly reported to both university senior management and to the council. So there should already be reporting in place that could be built upon for public reporting.
Yep. And have you had conversations with universities about making that across the board?
So we have staged our involvement. Our initial involvement was really intensive and related to incident responses. We are now engaging with universities and other stakeholders in a series of roundtables where we're looking at that type of system responses. So we've had a roundtable with the Minister and with senior university leaders and the Special Envoy, Ms Siegel.
Was that raised?
Sorry?
Was it raised?
That was not raised at that, but I expect that it will be raised in our further consultations.
Does TEQSA have the ability to raise these sorts of things in those roundtables? Like, is that something?
We do, and we're using these roundtables and our consultation with students to inform further guidance that we expect to issue about some of these issues broadly, and a very specific statement of regulatory expectations about complaints process and processes for academic adjustments and what we expect to see providers implementing and having done.
So, just to be clear for the purposes of Hansard, so TEQSA's view is that there should be, in line with the original French recommendations or the French report, that there should be some sort of public reporting on the complaints processes for university, and that you will raise that with universities? We
will certainly raise that. There is no, and you may wish to add, there is no barrier to that happening. That's completely consistent with the higher education standards framework.
And when do you think you'll raise it with universities?
So we won't have further roundtables this year. We will have further discussions and liaison with universities early next year, and we have a roundtable with Vice-Chancellors that we're scheduling for February next year.
February, okay. And that will be on the agenda?
Yeah.
Okay. If there's any further information around how and what recommendations you'll be asking universities to adopt, I mean, this is obviously would give a lot of weight to TEQSA's view as to what sort of complaints process universities should be adopting in our recommendations to the government and to the Minister around how universities can improve addressing anti-Semitism. So if this is something that TEQSA is actively raising or will be raising, that you have a view as to what you think needs to happen, that would certainly be ideally before the meeting so that we can incorporate that into our report. Given
that request, may I just add one other kind of element that we're looking at in this is that some but not all universities are doing good thematic analysis across their complaints. So there's a difference between dealing with complaints and using the complaints as a learning tool and as a tool to guide improvement and change. And we would expect that that would be included in our requirements and expectations of universities, is that the analysis and the use of that to guide improvement would be expected across the board.
Excellent. That makes a lot of sense. I think the purpose of this line of questioning, just to be clear, is clearly there is a huge range in the way in which universities are treating these complaints, whether they're reporting on them publicly, whether they're having a whole range of different experiences, whether students are being trauma-informed or whether the processes are trauma-informed or not, what happens at the end of it, what gets spit out. I think the approach by TEQSA of actively trying to improve that is an important one. I also think that, as you mentioned, the Student Ombudsman of being able to actually check against those sorts of processes is really important. But unless those processes are standardised, that they are best practice and they are trauma-informed, it does limit all of that. So I think that's the whole point of this exercise, is how do we ensure that students who have an instance, obviously we don't like that. I think there was an appropriate response right across the government and across the Parliament of trying to stamp out sexual assault at universities, and it was taken with utmost seriousness, and that was absolutely appropriate. And now we have this new challenge of anti-Semitism and other forms of discrimination on campus. It's just not just excluding anti-Semitism, but clearly there's a problem there as well specifically. And how do we ensure that universities have the best practice? How do we ensure that universities are publicly reporting on what happens? And how do we ensure that the students and the staff can have confidence in all of that? So any information you can provide on all of that would be very useful. I've got more questions, but I might hand over to the Deputy Chair.
Thank you, Chair. Dr. Russell, just on that complaints data that you mentioned earlier, I think that was included in your submission to the Senate inquiry that we've had. Were you only collecting that over a certain period? Have you got that up to date today?
We only collected, thank you for the question, we only collected that for 3 rounds, partly because the purpose was just to verify that the complaints pathways were being utilised, and partly because, and one of the things that we've learned is the data was very poor quality, in part because universities were receiving a mix of what we would now call complaints around very specific individuals and instances versus concerns, which might be a member of the public who had read something in the media, who contacted them to express a concern but didn't have a direct experience or direct evidence. Now, at the time that we collected the data, that wasn't sufficiently clear, and so we didn't want to impose too much of a burden for data collection, and it wasn't helpful to take that forward.
Yes, but the data that you provided to the Senate inquiry, that's up to date. That's the last.
That is the last.
Yeah. Okay.
Yep.
This is, I suppose, a question for any witness who has a view on the matter. But one of the themes that I'm picking up in the course of our inquiries has been that we're obviously seeing quite a lot of not just students but academics getting engaging in activity that we would be, the broader community would be concerned about and recognise as anti-Semitism. Does TEQSA, does the department hold a view on that theme? Is there concern, and is there any activities that have been undertaken by the agency or the department to address that concern at all?
I'll start.
Yep.
Thank you for that. And it was actually very helpful listening to Professor French, the previous witness, in terms of how codes of conduct play an important role, both staff codes of conduct and student codes of conduct. And in some of our advice over the encampments and in response to the encampments was for universities to think about whether their codes of conduct were still fit for purpose. And so that was the conversation that you heard from the previous witness around the role of definitions, but also the educative process to inform staff and students about what the expectations are and therefore what actions would be taken when those behaviours are outside the codes of conduct. So one of the things that is coming up through the round tables and through the broader work we are doing about governance and the work we've started in that stage process Mary just informed you of with regard to our follow-up action is requiring universities to think about whether their freedom of information, academic freedom and free speech, policies and procedures, this is the first time they've been tested really, are actually fit for purpose. And that also goes to the adjacent policies and procedures like codes of conduct.
Okay. Any comments from the department on that front?
No.
No. Okay.
Sorry,
go ahead.
May I just add?
Yes.
I think it is really important that the question of definitions is always considered alongside the code of conduct. We heard from Professor Pickering and Professor Chakma earlier that part of what was important to their response was their ability really quickly to identify where behaviour had crossed the line. Now, a definition is maybe a helpful tool in doing that, but it won't stand alone if the code of conduct and the education that goes around that are not both contemporary, strong and really joined up. And certainly from our discussion, well, from my personal discussions with a range of universities early on in the protests and encampments, that was one of the issues that some universities had tackled very decisively and others were really struggling with, was how to tell what crossed the line and what didn't.
Absolutely. A question for the department. What instruction has the department had from the Minister's office in relation to handling the issue of rising anti-Semitism on university campuses?
Thank you, Deputy Chair. The Minister has been very clear with the department going back to very shortly after October 7 that he was concerned about the potential for anti-Semitism to increase in this context, and his focus on making sure that every relevant effort was put into place to stamp it out and to reduce it. That's been a very prominent feature of his engagement with the department, and I might say with TEQSA, since that time. It's also worth putting that into a slightly broader context, if you don't mind, Deputy Chair, which is, I think it's clear that the Minister and the government have been very focused on student wellbeing more generally. And so if you look across the broad sweep of legislative activity over the past 18 months, we've seen the support for students policy legislated and now implemented, which is very relevant to these matters. For example, to academic considerations, academic adjustment. We've seen the introduction of the National Student Ombudsman, now very close to being in operation. We've seen the government's commitment to introducing a national code on gender-based violence, which, you know, a different issue, but some of the same kinds of concerns about complaints processes, about responsiveness across large and complex organisations also exist in that context. So I think if you take all of that as a whole, you would say that the government had concerns about how universities were managing these matters. Even the work that's happening on university governance is relevant here. And that the government has taken a number of actions led by the Minister to move forward on those concerns in a wide range of areas, including specifically in relation to anti-Semitism.
Okay. Thank you, Chair. I don't have any further questions.
Thanks. Does TEQSA or the department have any views on the boundary between freedom of speech and the freedom for students to be protected against vilification? Is there any views on how universities should be managing or thinking about or codifying protecting academic freedom and freedom of thought while also ensuring that students are not harmed at university?
That goes partly to my response previously around how we understand how universities have adopted and enacted the model code so that they do have policies and procedures around academic and freedom of speech. And as I said, our learnings through engagement with universities, the round tables, is that some of the understandings of freedom of speech and student safety and student impacts were unbalanced rather than balanced. Hence things like definitions, codes of conduct, and how universities are more able to make rigorous and consistent decisions around when a set of behaviours are anti-Semitic, but even more broadly are bullying or harassment. And I think what we have raised concerns and universities accept is that in trying to manage a perception of freedom of speech, they have inadvertently discriminated or isolated other sets of students. And that's the very deep work we are doing now through the round tables and the sort of guidance that we will move to in preparation for the forthcoming academic year.
So do you think that the balance hasn't been there? And
I think we have examples of where the balance has been very good. I think Monash was one where we have good examples, but we have other examples where reading students' submissions to the previous inquiry, talking to students, the experiences of students, we would suggest that universities were caught on the back foot and didn't manage it well.
And
so freedom of speech, as Professor French said, is bounded within law. Like, it's not carte blanche. And so how do universities construct the policy and procedural frameworks so that they can do both? Freedom of speech, but it has to be lawful and bounded.
And so is that something that you're actively talking to universities about?
Yes.
And are you looking to implement national standards on that?
Freedom of speech and academic freedom are already within the standards, as are expectations and requirements of all providers to meet their legislative responsibilities with regard to if the state has it, because this is the conversation about
Yeah, I know.
state.
I'm just trying to work out. I mean,
So providers have responsibilities under the standards already to meet all the equal opportunity anti-discrimination legislation that exists now.
And in your view, are they?
That is what we're testing.
Right. So we've got some universities are getting the balance right. Some universities are not. I mean, as the university regulator, what are you actively doing in order to ensure that all universities are getting the balance right, as you would say?
That's through the broad systemic consultation we're doing now with a view to the guidance we wish to issue in the beginning of next year. But I would also ask Mary to talk about perhaps case studies of particular universities. Is that a...
So before Dr. Russell comes in, so you will be issuing guidance to I'm sleepy and I've been travelling a bit and I've had a bit of a week.
That's right.
But TEQSA will be issuing guidance to universities early next year on a standardised approach that they should adopt in order to ensure that freedom of speech is adequately balanced against the freedoms that students should be experiencing on campus of not being able to be vilified, discriminated against, or adhering to the laws that would ensure that they are not harmed at university. Am I getting that correct?
TEQSA, under our TEQSA Act, doesn't have the authority to issue that standardised requirement as an absolute requirement. The way that we will approach that is issuing both guidance and a detailed statement of regulatory expectations about quite specific actions that we expect universities to have taken with regard to this issue, and that will be what we will set as the expectation, but also use for monitoring and compliance of universities. Now,
the timing of that will be?
It won't be until after we've had the further roundtable discussions in February. May I raise perhaps one more point that may assist the committee before reference to the HESA Act? Certainly we are doing some work with University of Sydney around this because there were obviously many examples of difficult handling of instances there. We conducted a site visit with University of Sydney in the last fortnight, and we'll have ongoing work. But I think in the Hodgkinson review that the Uni Sydney has commissioned, there's some extremely helpful commentary about the fact that understanding of what academic freedom and freedom of speech looks like needs to catch up with current legislative requirements about workplace safety and psychological safety. So the way that it has been interpreted and managed in the past is not sufficient for the university's contemporary management of those issues.
So, I mean, the reason why I ask around timing and why I'm sort of trying to dig into this is that part of the reason of this committee getting on with this work now is so that we can have improvements for students going back to university next year. So, I mean, is there any ability to really, like how urgent do you think this is, that students are protected at university?
So we think it's both urgent and important. So we are We are continuing the engagement with universities now, but one of the principles that we decided upon for issuing the guidance is that we want it to be sufficiently informed by students and consultation with students and understanding of their experience. And because of the period that students have just finished with the assessment period, and now many of them being absent from campus, it's more difficult for us to engage with student representative groups. But we don't want this work just to be informed by the perspective of the providers. We want to make sure that the student experience and student perspective feeds into the guidance that we issue.
And we have a range of planned student groups and student focus groups in January. Yep.
In January?
Yep.
Okay, and then when would the timing look to be for the advice or the guidance as
we
you
expect
put
to
it?
test and engage with Vice-Chancellors at the roundtable in February on what we will be taking forward. So that's one of the purposes of that roundtable.
And is your expectation that Vice-Chancellors would be amenable to these sorts of recommendations?
We've certainly had.
I'm not trying to trick you out. Because if we need to, if there is a problem where we've clearly got a situation where there isn't adequate processes that are happening across the board, or there isn't an adequate standardised approach, and the only powers that the government has is via TEQSA, that is to make guidance suggestions to universities. I mean, isn't that the whole point? Is that we've got to get a wriggle on here?
Can I? We want to test with Vice-Chancellors in February in case there's something, because we have obligations to consult. But at the end of the day, we will make decisions and we will issue either a statement of regulatory expectations, which has force in terms of our regulatory matters going forward, but we already have a range of what we call guidance notes, which provides providers with the broader expectations that we would expect in terms of how they meet the standards. As we move through this, we'll be clearer about the nature of what that will look like. But our aim is to have things in place for the beginning of the academic year.
And if I may add that we have written to universities on numerous occasions since the protest activity began, and we have issued an interim sector alert to set out some of those expectations about the work that universities should be doing now.
Okay.
Can I
please
add to that, Chair? I wouldn't want the committee to imply from that discussion that there wasn't urgent action happening right now with university leadership. In my experience, if not every Vice-Chancellor, close to every Vice-Chancellor is very actively engaged on these issues. There is the work led by Gillian Segal involving the Group of 8, but also Universities Australia. There's some very good work going on training about anti-Semitism through that group, which I'm sure you're aware of, Chair. So this issue is very much front of mind, and with all the best will in the world, the balancing of academic freedom of speech, and the need to protect against wrongful speech, unlawful speech, those kinds of things, it is a difficult thing to. It's not something that, with all due respect to colleagues in TEQSA, it's not something that a piece of paper sent to universities will solve. It's something that is more contextual and in the moment. So I think the wider context of all of the good engagement that's happening with the sector at the moment is very important in terms of elevating the urgency and importance with which this is being tackled.
I completely understand and agree with all of that, Mr. Rim. I'm more just that, TEQSA is the regulator, and to ensure that universities are actually we want the experience of one student to be the same as the experience of another student at another university, and TEQSA, I think, plays an important role. And if there is guidance that TEQSA does issue, I think it is really relevant to the recommendations of this committee.